So as you just heard, I've been a Daf Yomi learner with Hadran for the past 2.5 years, but I have been an attorney specializing in inheritance laws in the US for the past 18 years. So while the discussions about the Torah's inheritance laws may not have been the most interesting to every Daf Yomi learner, I was really interested. The first major difference I noticed between the two systems is whether a person has the power to control where their assets go after death. So under Torah law, a person doesn't decide who inherits their property upon their death. Their property ceases to belong to them because it has always really belonged to Hashem. So the Torah decides what happens to the property. The American legal system is largely built on the idea of personal freedom, like America itself. And inheritance laws in the United States are not one uniform system under federal law, but rather separately defined by every state. The states have largely adopted two systems, a common law system and a community property system. Under the common law system, spouses own their own property separately, and each spouse gets to determine how their assets will be distributed at death. Under the community property law system, spouses are deemed to own most property jointly, so each spouse can only determine how 50% of their joint property will be distributed at death. While these systems differ, both embody the American value of freedom of disposition. Upon death, with some limited exceptions, Americans are free to determine how they wish to dispose of their property. The Torah gives an order of inheritance, or Yerusha. Similarly, American law provides an order of inheritance. The major difference between these is that in the halachic system, this order is immutable. In the American system, this order is a default in place if a person dies without leaving a last will and testament. So this comes in just to fill in the blanks. The Torah lists out the general system of inheritance in Bamidbar, chapter 27, verses 8 through 11. Further, speak to the Israelite people as follows: if a householder dies without leaving a son, you shall transfer his property to his daughter. If he has no daughter, you shall assign his property to his brothers. If he has no brothers, you shall assign his property to his father's brothers. If his father had no brothers, you shall assign his property to his nearest relative in his own clan, who shall inherit it. Well, we all learned in a Mishnah on Daf 115a of Bava Batra that although the Pasukim say that if someone dies without a son, the estate passes to the daughter, others may come in line ahead of the daughter. In this case, if Noah died and was survived by his daughter Joni and no sons, you may have thought that Joni would inherit all of Noah's property based on the Pasukim. The Mishnah comes to explain that if Joni had a brother, let's call him Josh, but Josh had died before their dad Noah, if any of Josh's kids were alive at their grandfather Noah's death, those kids would inherit instead of their Aunt Joni. The Mishnah further adds that after sons or their descendants, or daughters or their descendants, the father of the deceased is the next in line to inherit, even though the father is not explicitly mentioned in the Torah's order of inheritance at all. The Mishnah on Daf 126b starts by restating that a person does not have the power to alter the Torah's inheritance laws, and if they attempt to do so in the context of inheritance or Yerusha, their words have no effect. Haomer, ish ploni b'ni bechor lo yitol pishnayim. Ish ploni b'ni lo yirash im echav lo amar klum. Shehi na al mashekatu b'Torah. So if someone says, so-and-so, my firstborn son, will not take the double portion, or so-and-so, my son will not inherit among his brothers, he has said nothing, because he has stipulated against what is written in the Torah. A person is permitted to make lifetime gifts or to incur debts. Inheritance laws only apply to what a person owns at the time of their death that is not subject to pre-existing debts. If a person gives away all of his or her property while they are living, that is permitted under Torah law. I say permitted because the next part of the same Mishnah on Daf 126b tells us a little bit more. המחלך נכסיו על פיו, ריבה לאחיו ומעט לאחיו, והשווה להן את הבכור, דבריו קיימים. ואם אמר משום ירושה, לא אמר כלום. With regard to one on his deathbed who apportions his property orally, granting it to his sons as a gift, and he increased the portion given to one of the sons or reduced the portion given to another, or equated the firstborn with the portions of the other sons, his statement stands. But if he said this in the context of Yerusha, he has said nothing. The Mishnah continues by explaining that a person does have the power to make gifts to their rightful heirs or other people, so long as they do so in the context of matanot and not in the context of Yerusha. The first part of the Mishnah we just read specifically explains that under Torah law, a person cannot disinherit their sons. Since you cannot change how your estate passes after your death, and since your son or sons are the primary heirs of your estate, you just can't say that they won't inherit. Another Mishnah later in the chapter in Bava Batra on Daf 133b states this explicitly. Hakotev et nechasav la'achirim v'hiniach et banav ma she'asa asui. Ela ein ruach chachamim nocha hemenu. So one who wrote a document granting his property to others as a gift and left his sons with nothing, what he did is done. It takes effect. But the sages are not pleased with him. While the person in the Mishnah has not technically violated halakha, it is clear from the Mishnah's reprimand that the Chachamim believed that the person had violated the spirit of the law. The admonition, Ein Ruach Chachamim Nocha Himenu, the sages are displeased with him, is severe as rebukes go in the Mishnah. Later poskim raised this rebuke to the level of an isur. For example, the Rosh rules that a person who transfers inheritance away from his son is considered to have committed an aveirah. The Gemara, further on this same daf, says, and I'll just read this in the English for time, what was the halakhic conclusion reached in this matter? Common here, as Shmuel said to Rav Yehuda, Shinana, do not be in a house where inheritance is transferred away from the rightful heir, even if it is transferred from a wicked son to a good son, and all the more so if it is transferred from a son to a daughter. Shmuel said that a person should not engage in abure aksanta, unlawfully passing an inheritance from one hand to another, or even be present when this occurs. We'll get back to this concept of abure aksanta later. In the time of the Mishnah, there was a debate as to whether disinheriting a son was justifiable or not. As we discussed, the Mishnah started with the opinion of the Chachamim, that a person who gifts away his property, bankrupting his estate and leaving nothing for his sons, Ein Ruach Chachamim Nocha Himenu, the sages are displeased with him. But the Mishnah also cites the opinion of Rabban Shimon ben Gamliel, who provides a justification for disinheriting a son. Rabban Shimon ben Gamliel Omer, Im lo hayu banav nohagim keshura zachor latov. Rabban Shimon ben Gamliel says, if he did so because his sons were not acting properly, he is remembered positively. Rabban Shimon ben Gamliel presumably was arguing that there are situations in which a person's sons should be disinherited. The Gemara sides with the Chachamim's opinion that disinheriting sons is problematic at best and strongly discouraged at worst. The 8th parak of Bava Batra opens with a Mishnah that explains that although a husband is the primary inheritor of his wife's estate upon her death, a wife is not an inheritor at all of her husband's estate upon his death. The ketubah, on the other hand, entitles the surviving wife to ongoing support until she remarries or demands the lump sum payment outlined in her ketubah. As we have reviewed, daughters do not inherit unless there are no sons or descendants of predeceased sons. So although daughters are not primary heirs, they may inherit depending on the makeup of the family. For example, my parents only have daughters, so my sister and I are both the primary heirs of my parents. Even when sons exist in the family, an unmarried daughter is entitled to be supported by the estate until she is betrothed and is due 10% of the estate for use as her dowry. So under Torah law, daughters do not inherit if there is a son, or the descendants of a predeceased son. That said, there are a few major techniques that have been employed to pass assets to daughters beyond what is required for their support. These are lifetime gifts, shtar chatzi zachar, shtar shalem zachar, and halachic wills. I will briefly review each of these. So as we talked about, parents can make gifts to their daughters, but gifts have a number of important limitations. They can only be made during a person's lifetime, and they have to have specific formalities. And because of the principle of ein adam makneh davar shelo ba'olam, a person can only make gifts of the assets that are in existence at the time of the gift. This means that since a person cannot predict what their estate will look like at the time of their future death, they cannot reliably equalize a daughter with lifetime gifts. The Ramah, commenting on the Shulchan Aruch and Choshen Mishpat, describes the practice known as shtar chatzi zachar. This practice is based on the idea that although a person cannot diverge from the Torah's laws of Yerusha, those laws divide a person's estate after the estate pays any debts. This is done by a father writing a shtar in which he obligates himself in a debt to his daughter, equal to the whole estate. The debt has two conditions. One condition is that the debt is only payable within an hour of the father's death. And the other condition is that the debt is deemed to be null and void if the sons agree to divide the estate per the father's will. In this situation, his will gives her a portion that is half the value of a portion passing to the other brothers other than the Bechor. For halachic purposes, when the debt drops out because the sons agree to split the estate with their sister, the sister's not technically inheriting, but rather receiving a gift from her brothers. This practice dates back at least as far back as the 14th century, where it can be found in the responsa of the Maharil. The mechanism known as shtar shalem zachar is identical to the previous shtar. Instead of the daughter receiving a portion that's half the value that passes to her brothers, she receives a portion that is equal to the portion passing to her brothers. So this option treats a daughter as equal to a son with regard to the estate. While traditionally these shtarot were written and given at the time of a daughter's wedding as a dowry, that has fallen out of fashion. Most contemporary American postgame advise the use of a document called the halachic will alongside a secular last will and testament. A halachic will largely relies on the same principles and mechanisms as the shtar chatzi zachar, shtar shalem zachar, including a conditional debt, but it's often executed in conjunction with the civil will and not at the time or at all connected with the wedding of a daughter. Whereas in the Mishnah, the suggestion of making gifts to pass assets to daughters to get around the Torah's Yerusha laws was strongly looked down upon in Ruach Chachamim Nochamim Himenu. These shtarot in the halachic will are not only not discouraged, today they're strongly encouraged. Rav Herschel Schachter, a Rosh Yeshiva at Yeshiva University and a leading posek in the modern Orthodox community, has said that in this day and age, a person should give daughters a full portion in their estate, along with sons, to avoid bitterness and acrimony in the family. Although diverging from the Yerusha laws outlined in the Torah should not be taken lightly, Rav Schachter and many other prominent postgame think it no longer qualifies as abure aksanta to give daughters equal shares with sons, so long as one of these halachic mechanisms is employed. It's possible to imagine that in the time of the Torah, the Mishnah, and the Gemara, daughters would not have had any expectation of a share of inheritance and generally would not have had a need for such because they would be supported by their husband's family. We are living in different times, and the risk to family harmony is now great. The same mechanisms used to pass money to daughters can be used to pass money to wives. A husband can make lifetime gifts to his wife, but those same limitations apply. So the shtarot and halachic wills that I described are all effective to pass assets to a man's wife upon his death as well. The American legal system allows a person to fully decide what happens to their estate upon their death, usually determined by a valid last will and testament. A will needs to comply with certain formalities. Think of the requirements of a shtar. Following death, there is a court proceeding known as probate, where a local court with expertise in this matter confirms that the will appears to comply with all the necessary formalities. Think of this as Siyum. The other major requirement of a valid will is that the person writing the will, known as the testator, must be competent to make a will. Now, this is actually a relatively low bar, but the testator needs to be at least 18 years old, understand the nature of making a will, have a general idea of their assets, and understand the natural objects of his or her bounty. This one means that the testator needs to know who their immediate family members are. Most American wills include a recitation of the testator's spouse, if they're married, and children. This section is included whether or not the testator is leaving any property to these individuals. It's included to show the testator understood the natural objects of his or her bounty. Testators fully aware of to whom they should leave their property, but whether they choose to do so or not is largely up to the testator. Based on American law values of freedom of disposition, the testator can choose to completely disinherit his or her children. Some people have good reasons to do this. Perhaps they don't have a relationship with their children, or their children are independently wealthy and have no need for the parent's estate. This is obviously a very different framework from the Torah's Yerusha system, in which disinheriting sons is just not possible. While giving away all of one's assets in one's lifetime so as to bankrupt one's estate such that one's sons end up not inheriting any estates is permissible, it's still, in the Torah system, it's still looked down upon, as we saw earlier. Under American law, though, to avoid widows being left penniless and needing to be supported by the state, states operating in common law jurisdictions created a system whereby surviving spouses, regardless of gender, could elect against the estate if they had been disinherited by their spouse. This means that the disinherited spouse could go to court and claim their rightful share of the estate, regardless of what the will said. This is not something that's employed often. Most spouses leave each other their assets before directing assets to pass to their joint children. Many couples have already discussed their estate plans and coordinated their plans. And if a couple chooses not to pass assets to each other at death, the surviving spouse is typically aware and in agreement with this plan. In any event, in the American legal context, a spouse cannot disinherit their spouse unless the surviving spouse signed a waiver during their lifetime. Prenuptial or postnuptial agreements typically contain such waivers, but otherwise they're not part of typical estate planning for most married couples. Although the American system is based on the freedom of disposition, protection of surviving spouses was built into the system as an exception to prevent surviving spouses from needing to be supported by the state when the family had money to support the surviving spouse. Now, these laws were all enacted when women did not work, could not own property, have their own bank account or other assets, but they are drafted in a gender-neutral manner, even though they were intended to protect women. The Torah's inheritance laws are based on a land-owning society where the land had been divided up between the tribes. Since passing property to women, who could then marry into other tribes and have the land passed to other tribes, would disrupt this system, the Torah inheritance laws exclude women, at least at first blush. As we have discussed, daughters inherited where there were no sons. This doesn't mean, however, that the Torah didn't value women or want them to receive assets. It simply means that the way to pass assets to women was inherently different from the way to pass assets to men. Wives and unmarried daughters received support through ketubot. Now, to me, these two methods of passing assets are both separate and unequal. But just because women were traditionally excluded from the Yerusha system, they were not left out in the cold. And further, as society changed, the halachic system adapted to those changes. The American system, like America itself, is built on the idea of personal freedom, and thus limitations on those freedoms are the exceptions and not the rules. Additionally, under the American system, a person has the power to direct what happens to their assets after their death through their last will and testament, in contrast to Torah law, whereby, in recognition of the fact that everything really belongs to Hashem, people do not have the power to direct what happens to their assets after their death. The Torah's Yerusha system comes in to direct what happens. The American system provides only a default if the person themselves has not exercised their freedom to dispose of their assets. While the two systems are based on different premises, both have mechanisms in their particular system to move assets to the next generation and to protect the vulnerable. The tools each employs to affect these goals are different, but to some extent, um, they allow people to work within their own system to have their assets pass in accordance with their values. Although we don't have time during Daf Yomi to go into this level of detail, I hope it was interesting to use this time for a deeper dive into the Yerusha system, the halachic techniques that have been employed over the years as society's structure and values have changed, and a short comparison with the U.S. inheritance system. Yasher kochach to all.